Okay, so on the record, and we've got the same case number, 831543. Counsel, since it's a new day, we've got somebody else assisting us. Would you mind making your appearances on behalf of plaintiffs first, please?
Sure, Your Honor. Good morning, Your Honor. Teddy Parker, Will Kemp, and Harry Pepperman on behalf of plaintiffs.
Thank you. On behalf of Real Water, please.
Good morning, Your Honor. Joul Odou and Matthew Kaufman, Eric Freeman, and Mark Love on behalf of Real Water and Affinity.
Appreciate it. On behalf of ETT DBA Terrible Herbst, please.
Morning, Your Honor. Valerie Rojas, non-Thomasig, Trevor Everett on behalf of Terrible Herbst.
Okay, appreciate it. Thanks very much. By you all's request, you would ask for today's purposes that we start with plaintiff's motion to strike ETT's answer or for lesser appropriate sanctions, document 536, ETT/Terrible Herbst opposition thereto 766, and plaintiff's reply, document 962. So, counsel, now, in light of this, you also have some tangential, but I thought this court's inclination is we handle this one first succinctly, and then to the extent that there's some high-end ones that you want to do, that we do those next. Does anyone think that we should do a combination of motions?
Your Honor, I think after the motion to strike, and I agree, there are some relationships between this motion and some of the remaining motions. And in part, some of the comments you'll hear in our motion will address the motion for summary judgment, of course. I mean, it's raised in supplemental briefing. I will try to keep them as separate as I can because I do believe this is a distinct, although related, arguments, I will say.
Okay. Are you all agree with that? It's just you have different standards and rules that are being cited for different provisions in case law. That's the reason why the court finds it to be more appropriate to keep them distinct.
I agree with Your Honor. Keep them distinct and separate.
Real Water agrees, Your Honor. I'm not even sure, and we can address it when we get there, but I don't believe the motion for summary judgment is still being pursued as to Real Water, but if it is, we'll take it up at the time.
And you can appreciate that's some of the side avenues. If we start going that way on the first one, we might end up not having the full clarity that everyone would like. So, okay. Then I noted the document numbers. Counsel for plaintiffs, it's your motion. Go ahead, please.
Thank you, Your Honor. Your Honor, Mr. Godfrey will be assisting me today, but he's doing it remotely, so he'll need to be able to control the screen. Is there any problem?
You're asking the wrong person. That would be a court recorder question.
It's all set.
It's all set?
She's got it taken care of. She's wonderful. Appreciate it.
Okay,
Thanks.
great. Thank you so much. So, Mr. Godfrey, if you're there, I can see you now. Perfect. Can you put on the screen the chronology, please? All right, so I see the calendar, Shane. I don't see the actual items on that year. Perfect. So, Your Honor, I thought it would be beneficial for the court to have some context chronologically to what was going on leading up to this motion to strike. And I thought this would save us some time, otherwise I would go longer. I wanted the court to know that plaintiff's complaint was filed in March of 2021, and ETT's answer was filed on August 12, 2021. ETT's initial list of documents, October 15, 2021. So over 2 years ago, Your Honor. Can I go to the next slide, Shane? Your Honor, we had our first status check in front of Special Master Hale in October of last year. I shouldn't say first, but first it's applicable to this issue. And then, not long thereafter, plaintiff served its first request for production of first request for production of documents, of course, first request for admissions, and first set of interrogatories. On December 30th, 2022, ETT or Terribles responded to those written discovery requests. And, Your Honor, I'd like for you to see the request for admissions, the request for production of documents. Their responses really aren't as pivotal to this motion as their responses to interrogatories. So, Shane, if you could show us ETT's responses to the interrogatories, please. And while Shane is pulling that up, Your Honor, I want to have the court consider, as a part of this discussion, Rule 16.1. And as the court is aware, under Rule 16.1A, subparagraph A, subparagraph 1, subparagraph capital A, the rule is that a party must, without awaiting a discovery request, provide a description of all the names, if known, the address and telephone numbers of each individual likely to have information discoverable under Rule 26B. I want that to be firmly set in the court's mind. I know how familiar the court is with Rule 16. But I want the court to consider that rule in comparison to the ETT's responses. Your Honor, may I go over there?
I'm going to leave it up to the court recorder. If she thinks she can't hear you at a certain point, then we'll may have to move you back. I'm fine with you going up there if that's easier for you. Let's just make sure we can hear you, okay?
Yes, Your Honor. Thank you. And I was going to wait until I actually got there to start talking because I know
Or do you want a
between
pocket-
here and there.
Do you want a pocket microphone?
No, Your Honor, I did really bad with that. I could probably never be a lounge singer. That pocket thing in the Gallagher case, I was messing that up. I don't know why, but it didn't work well for me.
No worries.
Mr. Kemp was able to pull it off, but not me so well.
Okay. So I think she's going to remind you to stay within arm's distance of that microphone you're right near. Okay.
Perfect. Thank you, Your Honor. And you can see these are Terrible Herbst's answers to interrogatories, Your Honor, filed. Put to the top. Thank you. December 30th, 2022. We received the actual verification the following in January, Your Honor. And I'll show you the verification just so you'll see who verified these answers. Could you go to number 6, please, Shane? Interrogatory number 6, the response. So interrogatory number 6 says, state whether or not any of your employees had any communications with an employee of Real Water Company in years 2018, 19, and 20. And if so, state the name of the employees of each entity and describe the nature of the communications. Their response is no. Not a single person did they have communications with, they being Terrible Herbst and Real Water. Shane, can you go to the verification page, please? Next page, that's the certificate of service.
This is the last page on my document.
Go to page 10.
Was it a different document? You said you received the verification later.
Yeah, but I included it in this, Your Honor.
Okay.
In fact, I actually brought it with me just to make sure. And I will tell you, Your Honor, while I'm pulling it up, and I may have to approach just to show the court the verification page. The answers to interrogatories were verified by Mr. Chris Kemp. And Your Honor, may I approach? And
First, if you can first show it to defense
Sure.
counsel to make sure they're okay with you approaching.
Okay.
Appreciate it. Real Water, do you want to see these or?
No, we have no position on this, Your Honor. Thank you for offering.
Sure.
May I approach, Your Honor?
Yes, of course. Thank you. Set one. Okay.
Thank you, Your Honor.
Thank you.
And he was the executive vice president of Terrible Herbst. He was with Terrible Herbst for 35 years, Your Honor. At least as of the time of his deposition. Now, Your Honor, I raised Rule 16.1 because Rule 16.1 is not confined to 18, 19, and 20, which is identified in interrogatory. Rule 16.1 required them to produce the names, addresses of every witness, and they failed to do so. Now, you'll say, Mr. Parker, okay, we have a Rule 16.1 violation. Typically, under Rule 16.1, if they fail to produce a document, they fail to produce or identify a witness, under Rule 16.1, that document or witness can be precluded from testifying. That's under Rule 16.1 E3A, Your Honor. And you're familiar with that. That's the easy answer typically. But, Your Honor, you're also familiar with the Valley Health Systems case. And in Valley Health Systems, and I bring that case up because there's several cases dealing with sanctions and terminating sanctions. In the Valley Health Systems case, 4th, 27 Pacific 3rd, 1021, the Nevada Supreme Court affirmed the striking of the answer because Valley Health Systems Council and Valley Health Systems failed to identify 3 nurses. You remember that case, Your Honor? These 3 nurses were interviewed by counsel. These 3 nurses informed counsel, and Valley Health Systems was aware of it, that they were concerned about this perpetrator wanting to be in the room with women. And they knew, they had an idea. In fact, they took a statement. And because they didn't identify those witnesses, the other side did not have an opportunity to examine them by way of deposition. We're not aware of them in terms of listing them as a possible trial witness. And the court said, that's it. The prejudice imposed by failing to name those witnesses supported striking their answer. And in fact, if you remember, the Hall Pringle firm was involved in that case, and they were actually referred to the bar because they were involved in the interviews with the witnesses and chose not to produce them. That's how far that court went, Supreme Court went, because of the egregious nature of not identifying appropriate witnesses. Now, what I thought, Your Honor, I may jump around a little bit, but I knew this, we got a lot of material here, and I know the court is giving me and the plaintiffs, you've indulged our request this morning to come before you at this time. And I may sacrifice some of my time on a motion for summary judgment. I think that one's so easy in terms of the case law. I think this one requires a little more attention, so I apologize. But when you consider that case, because this case is on point, all 4 corners of it, the Valley Health Systems case could not be more akin to where we are now. Their executive vice president, their head of marketing sales, those witnesses were not identified in their first initial ECC disclosure. Shane, show me, please, ETT's initial disclosure. This was done, again, in 2021, over 2 years ago, y'all. Can you rotate that? Perfect. And let's go to the witnesses, Shane. There should be the next page beyond the caption. Okay, great. I like it with 2 pages at the same time. That'll make me go faster, but rotate it for us. So you can see here, Your Honor, they listed 1 through 7 plaintiffs. They're all plaintiffs. Keep moving, Shane. Thank you. Next page. And if you could rotate that, thank you. Then you have PMKs for Real Water, Whole Foods, Milwaukee Instruments, Costco. Keep going. Nevada Beverage. And all witnesses listed by plaintiffs and defendants. They don't list a single ETT Terrible Herbst person by name, not one. Let's go to their first supplement. And before we do that, Shane, let's go to 2023 chronology first. So Your Honor, a lot more activity in 2023. And you can see ETT's first supplement was 2.5, almost 2 years later, May 16th, 2023, when their first was October 21. And let's go to that disclosure statement, Jane. So this is their first supplement, Your Honor, May 16th, 2023. And let's take a look at their witnesses. We got, again, the same plaintiffs, 1 through 6. And then they start with the 30B6s, all the way down to, they list Brent Jones, Blaine Jones, Casey Aiken, John Marlowe. Keep going. Milwaukee, Hannah, Whole Foods, UNF, and again now another ETT NRCP, and the Nevada Beverage NRCP, 30B6. Keep going. Costco, Jennifer King. Keep going. These are people dealing with investigations, Your Honor. All the way down to every defendant you can think of, every witness. Stop.
Can you go back up, please?
Go up.
Please.
Go up.
You went a little quickly on that. Go
Go
back to
up.
page 8. There. Okay.
So now, they actually identify Anthony Randolph, but not a single Terrible Herbst witness yet by name. Not one. Go to the next slide, please. Go to the next ETT supplement, which is September 25th, 2023. So we're closing in now on the end of discovery, Your Honor. We'll go back to the chart in a second. Second supplement, Your Honor. Keeping in mind the discovery cutoff is November 1, based upon the CMO. We list, Terrible Herbst list, now finally includes its own witnesses by name. They list Chris Kemper, who actually signed,
Okay,
verified the answers in interrogatories.
What number? Because
Could you go to, let's not speed by, I want to show the court Chris Kemper's name. Go down, it's further down. There we go, Your Honor. 47. Keep going. Walters, Brad Sexton, those three. That's it. First time we get by name, almost 2 years into discovery, these names, these Terrible Herbst employees. Now, it's not like these are obscure employees. The Executive Vice President, Chris Kemper, Mark Walters, and Brad Sexton. Now let's go down to the documents. Jane, I want to show the court what documents have been produced at this point. They produced their insurance records. Those have been produced. Keep going, Shane. And the new documents are spreadsheets of purchases. And these are the last 4 digits of credit cards for Mr. Hunwardsen, Your Honor. Keep going down. Keep going. Keep going. And that's it, Your Honor. Now, what you don't see, 2 years in, any documents related to promotionals, any documents related to any agreements. Now, they're claiming that there are no agreements. which is still strikingly odd to me, and we'll address that in a few moments. But no agreements, no promotional information, no emails, nothing between Terribles and Real Water. Two months left, less than 2 full months left from the close of discovery. They've had this case, they've answered over 2 years before. All right, Jane, now thank you, that's what I wanted to see next. So, Your Honor, I want you to see, again, putting things into context. The November 1st is the discovery cutoff based on the CMO. In the supplemental documents brought on by Terrible Herbst, they discuss the modification as to the expert deadlines, but this deadline never changed. It's the November 1st discovery cutoff. For Kemper's deposition, Your Honor, is October 3rd, 2023. And in between, you see plaintiffs send a second set of requests for production and a third set as well. And then you see the dates. And you'll see that we also have the date of Brian Breeden's deposition and Anthony Randolph's deposition. So all the dates are here for what we've done up till now leading to trial. Shane, show me ETT's third supplement of November 2nd, the day after the close of discovery, Your Honor. And in particular, I want to start with the witnesses. All the way down to 47, so the new one should come after 47. All right, Your Honor. Now, these are new witnesses. First time identified after the discovery cutoff. Brian Breeding, who is the VP of Advertising and Marketing. Why wasn't this person identified in 2021? Certainly, the relationship between Real Water and Terrible Herbst was an issue from day one in this case. And they choose to produce and identify Brian Breeden, the VP of Advertising and Marketing, the day after discovery closes. They also identify Ryan Prince, Paul Fleming. These are all ETT employees.
I pause you for one quick second.
Of course,
Is
Your
there any assertion that these were new employees?
No, these are employees that dated back, Your Honor.
Okay, go ahead.
Thank you. The point being is, these employees should have been identified in 2021, not the day after discovery closes, Your Honor. They knew these were issues in the beginning, they're issues now, and they chose not to in violation of Rule 16.1. And again, now let's go to the documents now. These are all experts, Your Honor, these witnesses that they're also listed. They're not pertinent to this discussion. Keep going. So this is additional insurance information. Continue on. Now, stop right there. They're producing, again, spreadsheets, Your Honor, the day after, but no promotional information, nothing. Nothing dealing with the anything marketing, anything advertising, videos, none of that stuff. But they produced, of course, their expert report, their rebuttal expert reports. Now, let's go to the following day, Your Honor. November 3rd, 2 days after disclosed discovery, ETT's fourth supplement to its initial case conference disclosures. No additional ETT employees are listed, but I want to go to the documents. Go to the documents for me, Shane. The first artwork slide from August of 2020, Your Honor, the first time that they're producing what I would consider to be advertising, marketing, or promotional information. 2 days after the discovery closed. Documents that they had since at least August of 2020 that should have been produced in 2021 when they did their initial disclosures. Your Honor, had the pleasure or not pleasure of being involved in some of the cases that the defendants identify as the standard. And you probably remember this, Your Honor. I'm older than you, but you probably still remember some of this at least. I worked under Rex Jameson when they were opposing the Nevada Power case. That's one of the cases cited by ETT. I tried the case, the Clark County School District case. This case, I don't know if this case is fully reported by the Supreme Court, but I handled the Delgado case against ETT 2006 when they tried to suggest that a car that their employees were driving, when their employee was drunk, killed someone. They tried to report that it was stolen, and then the officer came on the stand and said, no, that was reported long after the incident, and it appeared, at least when the jury awarded $10 million in punitives against them, that they were trying to use that as a way of escaping liability. That was the case in front of Judge Gonzalez in 2006. I think this is when this first building first opened up. I think we were one of the first trials in this building. The point being, Your Honor, the Nevada Power case was a destruction of evidence case. The Richardson case, and I bring this one up because ETT is suggesting that we waited on our hands, that we've waived the right to bring this motion. If the court remembers, in Clark County Richardson, that information came to light during trial. And the Supreme Court found, affirming the sanctions, that we had not waited. That information when it became available, we took the steps to do what we had to do, which is during trial, we put the judge, let the jury go for a week to have the evidentiary hearing, and then after that, impose the sanctions, which it also included monetary sanctions because of how much time and effort it took for the evidentiary hearing. So, Your Honor, that case does not stand for the proposition that they would suggest to this court. Your Honor, it is clear, very clear now, and I didn't attend the deposition of Mr. Randolph, but I had the pleasure of the last couple of days reading through his deposition. Your Honor, ET&T has suggested to this court in its supplemental briefing that Mr. Kemp knew about Mr. Randolph and knew what he was going to say because he met with him a year before his deposition. Now, I was really shocked because in our moving papers, we discussed Rule 3.4, Professional Conduct Rule 3.4, Your Honor, you're familiar, and how you have to be honest to the court, honest to your own opposing counsel. I want you to see, because they suggest, ETT's counsel suggests, that Mr. Kemp knew about it because of that meeting and was not shocked, and their failures to comply with 16.1, their failure to comply with the appropriate responses to interrogatories should be excused because Mr. Kemp had a meeting with Mr. Randolph.
Can you reference the document that you're referring to? You're talking about with this or with the supplement to the MSJ?
They combined their supplement. I have it right here,
Okay.
Your Honor. Hold on, let me show it to you.
Talking about the 12/18/2023?
And Your Honor, I will tell you up front, I don't know what the docket number is, but I have the
A
document
date,
with me.
yeah, title, date.
I do. It is December 19th, Your Honor. They found it. Here it is. Yep, it is December 19th, 10:45 a.m.
Okay. I thought you were referring to the December 18th, so that's why I wanted the clarification. Thank you so much. Go ahead.
All right. And so I want you to see for yourself, Your Honor, so you can contrast this to what ET&T's counsel has said, that Mr. Kemp's meeting with Mr. Randolph should have alerted him to what Mr. Randolph would say.
Okay. Okay, I am correct. Right, okay. Go ahead, please.
All right. And so if we were to go, Shane, can you bring up Mr. Anthony Randolph's deposition? and I want you to go to page 219. And Your Honor, if you were to look at page 219, it's clear from page 219, lines 14, says here, after you were subpoenaed, did you have any communications with Mr. Kemp or anybody from his office? Now, I believe Terrible Herbst thought that by simply suggesting and putting in their briefing that Mr. Kemp had a conversation with Mr. Randolph, that would suggest to this court that Mr. Kemp sat on his hands because he knew Mr. Randolph would give negative testimony regarding Terrible Herbst, and that would support their waiver claim. Your Honor, the first thing is, when I read that in the briefing, I said, well, where's the affidavit from Mr. Randolph saying that he spoke to Mr. Kemp and Mr. Kemp discussed ETT? Where's that affidavit? And then I said, well, if that affidavit is not there, then it's got to be in the deposition where Mr. Kemp talked about ETT. Well, this is what it says, Your Honor. Keep going. Not until this morning when I think we were just confirming that I was going to arrive. And have you talked to any other attorneys or employees or individuals or any other firms in this matter regarding the deposition today? I probably let people know that I'm being deposed, but I didn't, I didn't want to be here, so let me just be honest with you. I don't want to be a part of this, but I did speak to a personal friend of mine that is an attorney just to make sure that I don't, get myself in any trouble. Now, this was furthered. This conversation went on to the next page, and this is what I want you to see in particular, Your Honor. Go to page 220. Thank you. And Mr. Everett, I believe Mr. Trevor Everett, who's here in the courtroom, was questioning Mr. Randolph at this point. And he says, well, I don't have any other questions. I appreciate you hearing from me. Then it says, I'm sorry, 221. This is where Mr. Everett finishes up. He didn't go as far as the next examiner did. And on page 221, line 7, he says, the only thing let's start at 4, I'm sorry. Do you have any understanding of what the allegations are against Hannah Instruments in the real water lawsuit? The only thing I think was because our machines are used to test the product, that maybe that's the reason why they wanted to include you guys in this mess. And they said, okay, anything beyond that are you aware of? Go down. No, I met with Mr. Kemp. I don't know how long ago, a while ago, when this was first going on. I think we discussed Milwaukee ORT meters. And maybe that, brought all of this into play. I don't know. Keep going. And what did Mr. Kemp tell you about the ORT meetings? Well, what I can recall is that he was going to do some research and find out about the ORT meeting. Now, Your Honor, let's say that Mr. Kemp discussed the Terrible Herbst involvement. Mr. Kemp, a year ago, would not have had the benefit of knowing the names because they didn't provide the names in their initial disclosures, would not have had any promotional information. Oh, I apologize, Your Honor, I forgot to turn it off.
That's your clue that you need to finish up?
No, I just need to turn this volume on. There we go. Sorry about that, Your Honor. That was good. So he would not have had the benefit, Your Honor, of a complied with 16.1 disclosure. No documents, no witnesses, for him to actually question Mr. Randolph on Terrible Herbst's involvement. What we've learned, Your Honor, through Mr. Randolph's deposition is he had 10 to 15 meetings with Mark Walters. Mr. Walters was not disclosed until late. When I said late, in September. I'm not saying after the discovery cutoff, but late in the process, in the discovery process. It should have been done over 2 years before. The communications, emails, I was told Zoom, meetings. None of that was discussed or disclosed under 16.1 as required by 16.1. And as you're also aware, Your Honor.
Can you go back, please,
Sure.
to the Walters disclosure
Of course,
under
Your Honor.
16.1? Was it the same generic facts and circumstances, or was it?
Same generic. Let's go back. Shane, can you go back to the September 25th, 2023 ETT second supplemental disclosure, please? And let's go to Mr. Walters. I think he's 26, somewhere in there. Keep going. Oh, there he goes, Your Honor. 48. This witness is expected to testify regarding the facts and circumstances surrounding plaintiff's complaint, all cross-claims and third-party complaints. They don't mention the 10 to 12 meetings. They don't mention the promotionals. They don't mention anything. In fact, Your Honor, and you probably saw this in the briefing, they don't mention the fact that Mr. Walters is getting free water from Real Water as a part of this as a VIP executive for Terrible Herbst. They don't mention any of that. Same with Brad Sexton. If you could go up to 47, number 47. Same with Chris Kemper. None of that's mentioned, Your Honor. So ETT would have this court believe that for over a decade worth of promotionals, free water, advertising, marketing, their biggest single seller, that there's not a single shred of documents, other than this document produced 2 days after the discovery cutoff. There's no promotional agreements, no advertising agreements. There are not even drafts or proposed marketing information. You know, the 30-second commercials, the stands of billboards that they use and actually affixed to the pumps. One's inside, outside, nothing. Not a single document was produced, and you saw for yourself, Your Honor, until after the discovery cutoff. I don't understand how ETT can attempt to shift the burden to plaintiff in their supplemental briefing as opposed to confronting and addressing their violations for over 2 years under Rule 16.1, as well as their failure to properly supplement answers to interrogatories and requests for production of documents, Your Honor. Certainly, under Rule 33, they should have supplemented the information with the word no being what their response was in their initial answers to interrogatories, Your Honor. That was done again over a year before, Your Honor. December of 22, so almost a year. That's how long ago, Your Honor. So when you consider their violations under Rule 32, Rule 16.1, certainly in line with the Valley Health Systems case, their complaint, their answer should be struck, Your Honor. The other thing I would point out, and this goes more to the, not the Bahena case, Your Honor, to the Big D case, Big D Stubley. The defendant suggested there has to be a discovery order in place before you can impose this type of sanction. Well, that's not what Big D says, Your Honor. That case indicates that without a discovery order, the sanction of terminating sanctions can be imposed. And that's what we're asking here. I don't believe that there's any excuse that has been offered that support not striking, because certainly the significance of the prejudice, it couldn't be clearer, Your Honor. We've not had the benefit of any of these documents. One of the things that Terrible Herbst will say is we have this retention policy, this document retention policy, Your Honor, of only 3 years. And as a result, they wouldn't have anything dating back beyond the time of this complaint. Well, that makes no sense because the complaint was filed in March of 21. Terrible Herbst was made aware of the recall in March of 21. They should have placed a litigation hold, but they certainly should have preserved documents from 18, 19, and 20, and 21. No excuse for that has been offered, John. And I still think that it is strange because we were informed during the deposition of Mr. Walters that there is a software system that they use that he can pull information from. And he testified that he was never asked by anyone from Terrible Herbst to pull his emails or to pull that promotional information. That's what he said, Your Honor. And so the other individuals that were listed and identified later, Matt Osa, OSA, was the Executive Vice President of Operations. Again, Mark Walters is the Vice President of Purchasing and Sales. Brad Saxon was the Chief Information Officer. They failed to identify Kayla Adams, who worked under Mr. Walters, again in marketing. It is amazing to me how extensive the failure is to comply with Rule 16.1 and Rule 32 has been in this case, Your Honor. The other thing is they failed to list Robert Venezuela, who is the keeper of the incident reports. This is all derived from the deposition of Chris Kemper that I'm citing to you, Your Honor, whose deposition was taken on October 3rd. Brian Breeden's deposition was taken November 3rd, 2023. Again, he's the Vice President of Marketing and Advertising. He said that this is how I learned of Kayla Adams. Kayla Adams is the Director of Marketing for Terrible Herbst side of the business, and all of the promotional stuff would have gone through him and through Kayla. Mr. Randolph, formerly of Real Water, said that all of the promotionals would have been approved by Terrible Herbst, and in fact, in his deposition, even Mr. Herbst may have been involved. And Shane, can you turn me to page 209, please, of Mr. Randolph's deposition? So this is very late in his deposition. His deposition, I think, went into page 238 or 243. Mr. Kemp questioned him to page roughly 145. So these are the defendants questioning him, I believe, Your Honor. So they're asking him about approvals of the commercials. You can see that at the top. If you want me to go to the previous page, I can, Your Honor. It says, Mark could have passed it along to his marketing department, or it could have been Mr. Herbst at the time. He could have said, okay, I'm okay with running it. I don't know their process of the approval, but definitely would have sent it to them to make sure they were okay with it. Your Honor, there is no doubt that Terrible Herbst knew in 2021 their own marketing process, their own promotional process, their own advertising process, to not name these witnesses until all of them, until after the close of discovery, and to not produce any documents in terms of promotionals until after the close of discovery, or to even properly identify the few that they did late into this discovery process. Your Honor, you can see from the chart how much was being done to get this case ready for trial. And when you're doing what the defendants did, you make it almost impossible for the plaintiffs to get a fair shake at trial because you have hamstrung them throughout discovery. That's what happened here.
I'm going to have you finish.
Yes, Your Honor.
Right.
I am just about
Very
done. My thought is, Your Honor, that you can see just how pervasive the violations were. You're familiar with the case law. Your Honor, if you have any questions, I'm more than happy to address them.
I do not at this juncture, but I probably will when you do your final words after I hear from Terrible Herbst.
Thank you so much, Your Honor.
Appreciate it. Thank you so very much. Real Water, I understand you do not have any position in this. Is that correct?
We have no position, Your Honor.
Okay, thank you so much. Then Terrible Herbst, go ahead, please.
Thank you, Your Honor. Valerie Rojas for Terrible Herbst. It's interesting that we're now talking about Terrible Herbst 16.1 disclosures. because that is not how this motion started. This motion started, if I can refer Your Honor to page 9 of plaintiff's motion, with accusations that Terrible Herbst made misrepresentations on 3 occasions during the course of discovery. First, plaintiff claimed that Terrible Herbst lied when it stated that it had no communications with any Real Water employees in 2018, 2019, and 2020. Those dates are significant because Mr. Randolph stopped working for Real Water in 2015 and became a broker for more than just Real Water. The second accusation was that Mr. Kemper lied in his deposition when he stated that Terrible Herbst does not have any contract with Real Water or any Real Water entity. They still haven't proven that such a contract exists. The third accusation, which comes on page 10 and 11, is that Mr. Breeden somehow lied about promotional videos for Real Water when he responded to the following question. Okay, so from when you started until today, and when he started was 2018, you do not think there were any Real Water commercials on the gas pumps? Response: I do not recall any, no. The plaintiffs still haven't proven that that response is incorrect. The plaintiff's original motion cited a number of cases. They did not cite to Rule 16.1 or even Rule 37. But if you look at the cases that the plaintiffs did cite, those cases pertain to violations of Rule 37. Rule 37 says that the court can issue sanctions if a party has either violated a discovery order or failed to produce a party for deposition. That is the standard that we were working under when we responded to this motion. In response to...
Counsel, can I ask you, I'm hearing what you're saying, but I do have to ask a question because
I'm sorry.
as you were saying it, I go back to their introduction, right?
Mhm.
And if you go line 19 of page 4, right? Do they not state the falsehoods told by Terrible Herbst and the concealment of what is expected to be women's documents and videos regarding the comprehensive gas pump advertised for water was intentional misconduct to distance Terrible Herbst from Real Water? The truth is Terrible Herbst from Real Water. Then it says trials now 2 months, in line 25, trials now 2 months away, and there's no way to remedy the major discovery violations committed by Terrible Herbst. So are you saying that they limited their motions only to those 3 bullet points?
That's what I'm reading their motion, yes. That, if you look at their motion, Your Honor, those are the accusations that they make, that Terrible Herbst lied 3 times. They're very specific about that.
Right, but
On page 9, Terrible Herbst falsely claimed 3 times that it did not have any communications with Real Water in 2018 through 2020. And then it goes through the specific 3 points that I just mentioned, starting on page 9 and continuing through page 10. And so in support of that, in support of those accusations, the plaintiffs produced some specific evidence. The 2008 Real Water internal memo, the 2010 letter from Brent Jones to Mark Walters, an undated Real Water business plan, Mr. Hunwardsen's testimony that he saw Real Water commercials on a Chevron gas pump in 2016 and 3 real water videos and screenshots of those videos. But this evidence didn't prove or even establish that Terrible Herbst lied when it made those responses to interrogatory number 6 or in deposition. There's still no evidence of any communications between Terrible Herbst and Real Water in 2018, 2019, and 2020. The plaintiffs would like to superimpose Mr. Randolph and claim he is a Real Water employee, but he was not during those years. And Terrible Herbst understood that. And we provided Your Honor with both his testimony stating that, as well as his LinkedIn page indicating how he had moved on from Real Water. He was selling many products. There still is no evidence of any contract between Terrible Herbst and Real Water. So Mr. Kemper's testimony has not been proven false. In response to the plaintiff's reply, they didn't produce any evidence to show that Mr. Breeden lied when he said he didn't recall any videos being played on Terrible Herbst gas pumps in 2018, 2019, or 2020. Plaintiff is making these assumptions and have even stated in their motion that this evidence of these commercials and other documents create the strongest possible inference, their words, that somehow Terrible Herbst is concealing this information or lied in response to discovery and deposition testimony. In response to plaintiff's motion, Terrible Herbst filed declarations indicating their searches for any communications once again and found nothing. The witnesses stated they did not recognize these videos. That does not mean that Terrible Herbst has lied. So once Terrible Herbst filed its response to the motion to strike, the plaintiffs then took the deposition of Anthony Randolph. But as I indicated, Anthony Randolph was an employee of Real Water until 2015 only. Other than Mr. Randolph, who stopped working at Real Water in 2015, plaintiff still has not produced any evidence of some communications between Real Water and Terrible Herbst in 2018, 2019, or 2020. Plaintiff's interrogatory is very specific, and words are important. They did not make a broad sweeping request for communications. Plaintiffs would like to gloss over the fact that Terrible Herbst did not have a direct relationship with Real Water. Its relationship was with Nevada Beverage. Nevada Beverage is the company that had the contract with Real Water, not Terrible Herbst, and they have not proven otherwise. After Terrible Herbst responded to plaintiff's motion, they somewhat expanded their accusations, kind of changed position, and now Terrible Herbst supposedly lied about the lack of customer complaints and commercials. So we addressed those accusations. We showed that there was no evidence that those 3 videos displayed on Terrible Herbst digital gas pumps. And even if they did, that doesn't make Terrible Herbst's testimony false or Mr. Breeden's testimony false when he did not recall any videos. The other thing they came up with was that Terrible Herbst supposedly stated that it had absolutely no communications of any type with Real Water. And they produced the 2008 and 2010 letters. That still does not prove that there were any communications between Terrible Herbst and Real Water in 2018, 2019, or 2020, or that there's any contract or agreement somewhere out there. So in the brief filed most recently, the plaintiffs were a little more careful with their words. I noticed that they are now stating, in particular on page 3 of plaintiffs' supplemental or addendum brief, that Terrible Herbst erred in making these claims, that there were no communications. So now we are back to the original accusations. No communications. That's on page 3 of their addendum brief. And there are some slight changes because now it's on page 7. The accusation is that Terrible's errs in claiming that there is no foundation for the Real Water video ads. Also on page 7, Terrible's errors in claiming that there is no foundation that the Real Water video ads played on Terrible's gas pumps. All of these accusations, Your Honor, are not what is at issue in the motion. Nowhere in this brief, just filed the other day, I believe, is there any mention of Rule 16.1. Rule 16.1 in that argument we just saw is new. And that's because the evidence that the plaintiff submitted in their original motion, in their reply, and in their addendum does not support their accusations. Now we're talking about Rule 16.1 disclosures, but there are a number of reasons why those disclosures look the way they do. For example, the spreadsheet that counsel showed, Your Honor, on that disclosure did not exist until around the time it was disclosed. Why was it disclosed? There was a specific request for production of Mr. Hunwardsen's, I shouldn't say, there was a request for production of sales at Terrible Herbst that matched the last 4 digits of Mr. Hunwardsen's credit cards to see if we could match up the purchases that might be his at Terrible Herbst with some Real Water bottles, retail bottles. That raw data took a long time to run. First of all, it did not exist. They had to recreate a server. And the spreadsheet was created to assist the parties in summarizing the raw data, because when you looked at it, it just looked like a bunch of words and numbers. Another example is disclosing Mr. Breeden. Mr. Breeden doesn't know about Real Water. He never had communications with Real Water, is not aware of any contract with Real Water. He was not going to be called to testify in this case until the plaintiff specifically asked for him. Although he started in 2018, he was not there from the beginning. And the most he knew about was searching back and locating the coupon. That's it. So if we're going to be going into Rule 16.1, that is not what this motion is about.
And counsel, can I ask you a question there? Because 16.1 has affirmative obligations. Are you saying that plaintiffs need to specifically point out those specific obligations for the court to address them? And or are you saying that you all complied with 16? Because 16.1, right? And it
Right.
references to 26, right?
Right.
And mandatory obligations to supplement.
Right.
And you know your per se, your disclosures on those witnesses are per se inappropriate, particularly since 2019 amendments. Okay? It clearly says, and there's specific languages from our former Discovery Commissioner, now Court of Appeals judge, and others that clearly say that what you wrote is inappropriate, right? And it needs to actually fully describe. So are you saying that the court cannot address those issues when there's affirmative obligations, or are you saying that the court shouldn't address it today because it was news to Terrible Herbst because of the way the motion was done. I'm trying to get the sense of what really, because gave everyone supplemental briefing, not necessarily additional supplemental to supplemental, but I've read everything and I'm taking everything into account. So I'm just trying to get the concept of where we are today for what your position is on what should be before this court, and maybe not before the court.
I think what's before the court is the motion to strike the answer based upon alleged false testimony and responses, and that should be denied. If there's a different motion based on Rule 16.1 disclosure, that should have been made already and wasn't. I'm not saying, I can't go through all of what they just brought up today. That's new. And that's because they didn't prove their original motion, Your Honor. But I can assure you, I recall many parties in this case giving those same types of disclosures.
Oh, please, to this court, do not say.
Well, I should be given an opportunity.
Can I at least finish my statement?
Yes, Your Honor.
So where I'm saying is there's actually, right, and it's for those who've had the pleasure of being in front of discovery commissioners, right? And remember, since this is a business court case, obviously it's this court which handles discovery. So this court has to look at all of the rules with regards to discovery, and consistent with various opinions, administrative orders, etc., there is an individual requirement. Because someone does not do something does not make it, well, they all broke the rule too, right? I mean, that's...
I get it.
So what the court's grappling with is to everyone, right, is counsel's correct. There's not a 37 mentioned in the initial pleading. There's not a 16.1 mentioned in the initial pleading. But those analyses are different, right? 37's got certain parameters in the notice to be heard, and you've got a line of cases with regards to 37, and then you've got courts inherent, right? And then you've got 16.1, you've got a lot more, but those are the three ones that seem to be where you are today. So what this court is trying to get a better understanding is you all have trial on the 16th. The chronology is the chronology. Nobody's disputing it because those are file stamped documents that the court was shown, right? And the pleadings. You're not contesting that those are not what the pleadings say that were shown to the court. Is that correct?
That's right. What pleadings, Your Honor?
Mr. Parker, what was put up on the screen by Mr. Godfrey?
Yeah.
On
No,
behalf?
I'm not
Okay.
disputing that.
So where this court is trying to just, for clarity, right, to narrow in what's actually before the court, is have an understanding in light of the changes that have been made in the additional supplemental briefing that people were able to do, is to have a clearer concept of realistically what each of y'all's argument is. Heard the rules, heard the aspects, my counsel for plaintiffs, but is your response that this court should only be focused on those three pinpointed things that you assert were in the initial motion?
Yes, Your Honor. They wanted to bring a motion on Rule 16.1. They should have done that, and they did not.
Is there anywhere in
read it.
16.1 that you're saying that they have to bring a motion for 16.1 as opposed to 37?
A motion to strike the answer. I think due process, we have an opportunity to know what we're fighting against.
Look, I'm just, like I said, I'm trying to get the concept.
Yeah.
I can't read your mind. Okay, like I said, I got the beautiful crystal
Sorry.
ball that my last extern gave me. It's beautiful, it's crystal, but it doesn't give me any powers to read people's minds or read future or anything like that. So, okay, thank you. That's why I just wanted that point of clarity. Make sure everyone's on the same page. You've got a procedural argument, you've got a substantive argument. Go ahead, please.
Your Honor, I was just getting to the plaintiff's last brief. I mean, I think we've addressed that, and I'm not going to belabor the point. I think the court is or should rule on the motion, the actual motion that is before the court, the accusations that are before the court, and deny the motion because nothing has proven those responses false. And that's why we had the parade today of 16.1 that is coming up for the first time. So initially, Terrible Herbst would ask that the motion be denied outright. If the court is going to somehow consider these brand new arguments, then the Terrible Herbst would at least ask for an opportunity to respond. And with that, I'll submit, Your Honor.
I appreciate it. Thank you so very much. Counsel for Terrible Herbst, go ahead, please. I mean, counsel for plaintiffs, my apologies.
Yes, sure. Your Honor, one thing is clear. One thing is patently clear. Because ET&T's counsel did her best to stay away from their opposition and their supplemental briefing. Because the supplemental briefing actually supports our position, Your Honor. Mr. Kemp knew nothing about Mr. Randolph's relationship with Terribles when he met with them. And that was the heart of their supplemental briefing. The other thing that's clear, Your Honor, and I appreciate your questions, because you asked the question and you gave defense counsel an opportunity to respond, and she failed to do so. Your Honor, you and I both know under Bahina, which is referenced in plaintiff's motion, Rule 37 and Rule 16 are prominently discussed in that case. Shane, can you please bring up the Bahina case that we spoke about last night? You on the mic, Coach, again?
Yeah, of course.
Thank you.
I'm sorry, Mr. Parker, I don't have that case handy. What's the citation?
Of course. It's 235 Pacific 3rd, 592. I thought we emailed it to you, Shane. I apologize. Your Honor, while he pulls that up, I don't want to waste a lot of time. Certainly.
Do you want to hear the court's question on 37 then?
Sure.
Okay.
Go right ahead, Your Honor.
As you know, 37 on its face, the rule specifically says, right, upon notice and an opportunity to be heard. So are you asking this court to make a determination under 37 when 37 is not, the rule itself is not specifically cited in your motion? Now, if you tell me it is, feel free to point me to the page in the line.
The motion does not specifically say 37. You know, and I am so familiar with Rule 3.4 that I stay way of violating it. It doesn't say 37 in the motion.
Okay.
The case law does. The cases we cited in the motion, the Bahina case specifically deals with Rule 37 and 16.
But where the court's question was going to be is, are you contending by citing a case that has a variety of different propositions without specifically citing it for the proposition you may be wishing to address, that puts another party, i.e. Terrible Herbst, on notice that this could be a 37 and that 37 allows that on its face?
Absolutely. And let me tell you why.
Okay, let me hear why.
If you look at their opposition, Your Honor, to this motion, if you go to the legal analysis.
Give me a quick second, 766. I'm referencing document 766?
Yes.
Okay, give me a quick second.
Yes, Your Honor. And when the court gets there, just let me know.
I appreciate you maybe have a few entries in this case I need to get through.
A few. That's speaking very nicely of the hundreds.
Almost
We're getting
1,000?
close to 1,000.
Almost 1,000. Okay, so sure, go ahead. What's the page, please?
If you go to page 10, this completely annihilates this argument of no notice. Lines 23 and 24 specifically go to Rule 37B2. So for ETT's counsel to suggest they were not on notice of the implication of Rule 37, given our it's also cited on page 11, line 18, as does the citation to the Clark County School District Richardson case, which deals with Rule 37 and 16, which is line 5.
I'm appreciative of that, and the court in asking us a question was appreciative that and was stated both in oral argument and in the brief, right?
Yes, Your
Is
Honor.
only one portion of 37, right, which goes to discovery and failure to appear for the deposition. There's many other subparts of 37, which include a cross-reference to 16.1.
Absolutely, Your Honor.
But are you contending, since they put in their opposition a defense to a certain portion of 37, that they should have known that you would be addressing a different portion of 37?
Well, I believe that because they referenced 37, and 37 in of itself speaks of sanctions, not under 37, not only under 37 generally, but 37B1 E speaks of dismissing the action or proceedings in whole or in part based upon sanctions, based upon a failure to comply. But I think 16.1, Your Honor, you get to the same conclusion. And it's because, Your Honor, and you've said this before, when you sign these pleadings and you sign these discovery responses, you're doing so as an officer of the court under Rule 11. And so under Rule 16, when they identified back in 2021 their list of witnesses that did not, after the 2019 amendment, Your Honor, in 2021 did not include any of these witnesses, and then 2 months before trial you named some of them, and then you named the rest of them after the discovery deadline. Your Honor, the other thing I would point out to you is that they were given an opportunity after raising the issue on Rule 37. They were given an opportunity to do supplemental briefing. They knew that their disclosures were inappropriate. They knew that their responses to interrogatories, that there were no communications, was incorrect. That's certainly undisputed at this point. Your Honor, what I also would point to is in Bahena. Bahena discusses that a discovery order, be it a discovery commissioner order, and then in that case it was a discovery commissioner order, was sufficient. The Special Master Hale in this case is acting as a discovery commissioner. His CMO is tantamount to a discovery commissioner order and is approved by the court. Certainly they can't run and hide from that. And if you look at the opinion of Bahena, Your Honor, and I apologize, but I thought we had it in our system. This is Justice Gibbons' decision. You're familiar with it. The first paragraph.
Every week. Go ahead.
Yeah, exactly. The first paragraph discusses NRCP 37. It also discusses Rule 16. Every case that we've cited, typically because it's terminating sanctions, addresses 37. So yeah, we didn't reference Rule 11. But they know the obligations under Rule 11. They know the obligations under Rule 37 if you're practicing here. You know the obligations under Rule 16.1. To simply say that they could turn a blind eye to those obligations because it was not specifically mentioned in this motion, I question the legitimacy of that argument. Your Honor,
The court has to ask you another one on
Oh, go
37
ahead.
scope before you move on, if you don't mind,
of course,
please.
Your Honor.
The court did not see the certificate under 37A, 1, in the motion,
That is true.
plaintiff's motion,
That is true.
then you know I can't treat it as a 37.
You can still do it under 16. Your Honor. And if they want additional time to address under 37, that's fine. But, Your Honor, I want to show you substantively some more facts, actual, something that you don't have to take my word for.
No worries, okay.
Mr. Godfrey, can you go to Randolph deposition? There's a couple of pages I want to show the court. And start with page 33, please. And then we'll get to Breeden, Your Honor, and then we'll be done. So, Your Honor, at the bottom of this page, lines 21 through 25, it says, so you had meetings with someone who was a buyer for Terrible Herbst. Answer, correct. And who would that be? Mark Walters. Switch going forward to page 34, Your Honor. Going towards the bottom, line 23. I'm pretty sure our first line of communications was probably by email, I would think, or possibly phone call, but it led to in-person meetings. Go to the bottom of 35. But but anyway, you went and met with Mr. Walters in his office? Yeah. More than one occasion? Yeah. Dozens of occasions? Yeah, I would say over the time frame, yes. Line 14 and 15, are you comfortable with 10 to 15 meetings? Yeah. Your Honor, we became aware of this when this deposition was taken. We didn't have any of this information. They say no in their answers to interrogatories. No. That's a flat out misrepresentation of the facts. A complete falsity, Your Honor. The other thing I would point out, Your Honor, go to page 189. This is something that ETT's counsel just said to you as a defense to this case, to this motion. ETT's counsel said that because Mr. Randolph became a consultant as opposed to a direct employee, that it made a difference. This is what he said on the topic. Page 189, line 10. As far as meetings go, was this before you were an independent contractor or after? Or if you don't remember, more of them occurred after or more or them occurred before? The question's kind of weird, Your Honor. We're using 215. I don't think my employment status made a difference on any meetings with Mr. Walters, with Terrible Herbst. He testified, Your Honor, that after he became a consultant, he continued meeting with him on an as-needed basis. That's his testimony. Can you go to page 137, please? He's shown pictures during his deposition of advertisements. Line 8 and 9, Mr. Kemp's questioning and says, these are pictures from Terrible Herbst's Instagram, Facebook accounts where they were promoting this still advertising program. At the bottom, he says, okay, then he goes on to continue discussing these. And the last question on 37 says, now prior to today, did you know that Terrible Herbst was running coordinated Facebook, Instagram advertising programs to promote these still bottles in August and September of 2020, Your Honor? He said, I would. Now, how do you have this massive social media promotions going forward and not produce any for 3 years, Your Honor? It is impossible. Impossible. And that's under Rule 16.1. Finally, Your Honor, I want you to show Mr. Breeden. This is ET&T's employee. Can you go to Mr. Breeden's deposition, line 41, please? So, Mr. Breeden, again, Your Honor, was the head of marketing, I believe, vice president, head of marketing and promotions at Terrible Herbst. And page 41, line 18, he's being questioned regarding promotions with Real Water was just still. It says, correct. Do you know approximately when they ran? August and September of 2020. Now, this is their own employee telling us that those promotions were ran in 2020. And yet in 2021, they produced nothing. 2022, they produced nothing. And not until after the discovery cutoff did they produce anything. That's a violation of Rule 16.1 by their own witness, Your Honor.
Can I interrupt you a quick second? I need
Oh, of course,
clarity
Your Honor.
between the stills and the videos, because the court's already ruled in the stills in a prior motion, IEC last week, but the videos we were deferring for a variety of different reasons. So the videos came to the knowledge of plaintiffs how? Can you refresh the court's recollection?
And I may have to defer to Mr. Kemp for 1 second, Your Honor, if that's okay.
That's fine. I'm just, since you're mentioning both in this, I just want
am.
I just want clarity.
Your Honor, we did an internet search and we got them through the internet. No party produced them.
Okay, thank you.
And that's this hunting expedition we've had to go on because they keep claiming nothing's out there, Your Honor. This deposition, Mr. Breeden's deposition, Your Honor, was taken in November. This is how prejudiced our position has become because of their failure to comply with Rule 16.1. He then says on page 43, Your Honor, lines 13, question starts. So is there some sort of record keeping kept with regards to this pump and pour program? So Your Honor, the pump and pour program is when you're at the pump, you're pumping your gas, and an advertisement comes on the screen there, and it says, hey, you get some free water, punch this button, you get a coupon. And we've showed you coupons in prior motions. You go take the coupon into the store and you get a free bottle of water. It says, yes. So if we wanted to, we could see how many times people press the button for real water in August and September of 2020. Response, I don't know those numbers, but I'm assuming we would be able to get them. Yeah. The data is still available somewhere? Yes. Your Honor, we still have not received that data. Now, if you could go to page 52, please. And this addresses the 2018, Your Honor. Lines 8 through 11. Question, if Real Water was running some video in 2018 on the Terrible Herbst pumps, would that come through your department? Yes. Just to let you know that the person we're deposing actually had something to do with the marketing promotions of Real Water, Your Honor. If you could go to page 55. And this is what bothered me because under Rule 16, Your Honor, this is something that's incumbent upon the party when they sign that Rule 16.1 disclosure. Lines 24 and 25. Okay, and as of this time, have you done any sort of email search for any emails and from you and anyone at Real Water? No. Your Honor, they've not done a search. They've done nothing to identify any of the emails between Real Water and Terrible Herbst. The person who is in charge of that department is saying that in a deposition under sworn testimony circumstances. Now, I think it's clear, even if you don't necessarily apply Rule 37, which I believe you can, because from the motion to the opposition to the reply, all the way to the supplemental briefing, they all reference cases that impose terminating sanctions under Rule 16 and 37. So but I do, Your Honor, again, I concede the point in terms of the motion and in terms of the certificate, but that's not a requirement under Rule 16.1, and certainly not under the case law. Any other questions, Your Honor?
I do not.
Thank you so much, Your Honor.
Well, not specifically to your thing. Okay. I'm going to do the following. I'm going to tell you where the court is currently inclined / has some thoughts. And then I'm going to determine if everybody gets an opportunity to have a few moments to address such. In Real Water, I'm going to give you an opportunity as well, because part of what the court's thinking about may be something that's stated in front of a jury. And if you have a position, I think the fair thing is to let you set forth the position because, well, it is the right thing to do, and the law supports it. So let's walk through where we're at. The motion as presented to this court does not comply with NRCP 37. Mandatory language in 37A with regards to certificate, and there's a good reason for it, and the cases do address that because it's putting the person on notice. I'm not calling it similar to a Rule 11, but the most analogous really is a Rule 11. So when you have to look at the mandatory language in the rule, and it doesn't have a carve out, it doesn't have unless otherwise ordered by the court or anything like that, it's mandatory language on 37. I do not see that there's a waiver by mentioning in opposition what 37 may entail. I don't see that there's the notice of putting it in case law in the motion somehow would alleviate the certificate requirement in 37. So that means this court cannot address this current motion under NRCP 37. And for language purposes, just so everyone's clear, 37A1, on notice to other parties and all affected persons, a party may move for an order compelling disclosure or discovery. The motion must include a certification that the movement has in good faith conferred or attempted to confer with a person or party failing to make disclosure or discovery in an effort to obtain it. Author of cases that talk about that, whether it's in this context or even it's in the motion eliminate context under ADCR 2.47. Regardless, it's a mandatory requirement. It's not here. The court cannot address this motion under 37. In light of that, the court doesn't see that there is a basis to do an evidentiary hearing because the court is not going to consider terminating sanctions. Because while the court is cognizant of the court's inherent power, the court's cognizant of the affirmative obligations under 16.1, and the court's cognizant of how the motion is presented and the rules of professional conduct issues raised in the motion and the citations to the various cases, the court doesn't find that there has presented to this court that the court should consider terminating sanctions. Therefore, the court's not going to do terminating sanctions. Therefore, the court does not think an evidentiary hearing would be necessitated or appropriate. The court, however, is considering lesser sanctions. But I need some guidance here on sanctions that are being sought, because it does not have some specific examples of other sanctions. The motion itself does request some lesser sanctions. The concept of lesser sanctions was clearly on notice for Terrible Herbst, so they had an opportunity to respond to that in the breadth and scope and what they thought sanctions, whether it should be 0 or something less than terminating sanctions. Okay. So, and the court finds it's appropriate to address those because there's a variety of different things. One, there's affirmative obligations under NRCP 16.1, regardless if it's specifically mentioned in a pleading. Also, actually, and the court referenced the page right after the 3 bullet points, the general discovery is not only there in the page that the court referenced, it's right there in the motion, but it's also referenced at other aspects with regards to the disclosure of the documents that would have not been produced, the fact that there's lack of information. So the court would find that there's enough notice that would be appropriate to respond to the concept that if any party felt that they had, and here specifically Terrible Herbst felt that they had complied with all of their obligations, that they could easily address it, and they can't self-narrow it into just because the motion did include some bullet points on specific topics. It also had the more general. So it had both a macro perspective and a micro perspective. The court finds that that gave the opportunity to be heard under the EDCR for opposition purposes, for notice purposes, also under general due process. Plus, you all had supplemental briefing. They had an opportunity there as well. And even supplemental to supplemental, they came in as late as
Yesterday.
Yes. That being said, so the court does find that everyone's had a full opportunity to address, and that since they're mandatory requirements, everyone's on notice of them anyway. So the court has the opportunity to address 16.1. The court also has its inherent power. The court also has the notice aspect with regards to the motion. In light of all of those, the court does find that there's violations of 16.1 that's tied into 26. There's also violations that have of deadlines set by this court. When I say this court, I'm using it in a broader sense because here you have a CMO and you have coordinated discovery. But in not providing documentation, notice of witnesses, etc., it provides 16.1 violation. It also provides a violation in general of the rules in order to put people on notice of what individuals' claims and defenses are going to be presented, the witnesses that are going to be presented, the documents that are going to be presented. There's not been anything presented either in the pleadings or an oral argument that said that there was any good cause for the per se dates. And then the questions the court did ask, did anyone disagree with regards to the actual chronology of events and the actual filed dates of the various documents? So given all of that, there needs to be sanctions. Now the question becomes, there's a variety of different sanctions with a variety of different support for said sanctions. So I'm going to walk through. I'm going to ask plaintiff first. I think the fair thing to do is to ask plaintiff first, what is their request for lesser sanctions? Then I'm going to give Terrible Herbst an opportunity to respond. If Real Water thinks that they wish an opportunity to respond, then I'm going to give them an opportunity to respond. I will tell you some of the various sanctions that the court was contemplating before I ask plaintiff, just so everyone has an opportunity at the same time to hear things. Sometimes parties request a trial continuance. I did not hear that a trial continuance was being requested, so realistically that was not in the bundle of options that the court was thinking it should consider. But if that is different, I'm going to ask counsel for plaintiffs if that's something they're requesting, because then you have the opportunity potentially, by the way, of course, the court's find prejudice, because not knowing any of the witnesses that are key to the claims, okay, there is prejudice, and based on the dates, I mean, first witness wasn't even disclosed until the eve of your discovery cutoff, and there was no request to continue discovery or say that there was any reason why those witnesses could not have been disclosed either, which is what the court should have mentioned a moment ago, which is one of the reasons why the court asked the question whether or not these were new individuals, basically new hires, new, some issue that would give some good cause. There isn't. That's been presented to this court. So continuance of a trial date, reopening up discovery for a limited purpose to allow certain information is one potential. I'm going to have to hear if people are requesting that. Another one is really the court's inclined, while the court had procedural concerns on Randolph, is that Randolph gets to come in. I'm going to ask Real Water their impact on that, because to the extent that there was some procedural issues with regards to Ren, the reason why the court will find it's appropriate here is because witness number 44, disclosed in May of 2023 on Terrible Herbst's own witness lists. In fact, the first witness that was disclosed instead of Terrible Herbst's witnesses was Randolph, so they were anticipating that potentially he could be called on their behalf because he affirmatively appeared back in May, so they can't say that there's a prejudice that it wasn't in this case, and so therefore if they chose not to take the deposition, then what the court's really looking at is the timing of the deposition. Does the fact the deposition took place in December have a negative impact on Terrible Herbst? Like I said, I haven't heard yet from Real Water, so I'm appreciative of that, but I'll give you a chance in just a moment. But at least from Terrible Herbst, they can't claim a prejudice when they named Randolph back in May. The timing of the deposition in December, to the extent it may have been done in Wren, you all had an extension of discovery till late November. Here you have names listed by Terrible Herbst in November after the discovery cutoff. So there's a good faith basis this court would find that Randolph potentially could come in. Once again, I'm going to hear these as potential sanctions. I'm also going to see if the parties are going to request that I address the Randolph issue separately because he's part of a different motion in some respect, but I'm giving you an inclination from a sanction component versus a general procedure and substantive, which I may be addressing shortly. Another thing that the court was considering whether or not there should be a specific statement stated to the jury, and that would be created by the parties, approved by the court. And if there was a disagreement, the court would have to rule on it. Some type of statement which would be similar to the destruction of evidence type statements in a Bass versus Bass Davis, but on a flip side, but that it sets forth that information that basically sets forth certain witnesses were not disclosed until an X date, and that the jury can potentially consider that. Another potential sanction the court was evaluating in light of other motions before the court is that those videos come in automatically because as a sanction, they should have been disclosed. I appreciate it. Thanks so much. Okay, we're back on the record. I have all counsel back on the record. Did everyone have sufficient time to evaluate whatever you needed to evaluate? Counsels for plaintiff?
We did, Your Honor. Thank you so much.
Counsel for Terrible Herbst?
Yes, Your Honor.
And counsel for Real Water?
Yes, Your Honor.
Okay. So I said I'd go first to counsel for plaintiff since you all were the movement. Let's hear your thoughts and then we'll circle around to everybody else. Thank you so much.
Thank you, Your Honor. And again, we appreciate the court's willingness to hear this early this morning and in between so many other things. Your Honor, we do believe that a statement to the jury would be appropriate. Number one, we do believe that we will have to work the details of that out with Real Water and with ETT's counsel because we believe this statement will have to reflect virtually the violations that occurred without giving the rules and putting them in the statement. So we have to kind of work out the dynamics of that document. But we'll prepare one. It would include the failure to identify witnesses, the failure to identify documents, and the false verification of the Rule 33, which is the interrogatories. Your Honor, I wanted to...
The court was not heading that was a determination that was a false verification at this juncture because there is, I would say, a lack of clarity in the response. If you're asking for that one, I would have to do an evidentiary hearing to get specific clarity, right, on how that response came, whether he verified that one specifically, right? I appreciate the verification for the entire aspect. I appreciate that that's what it says on the verification you came up and showed me, but there's some outstanding questions on whether this court could find it, quote, to be a false verification.
So, Your Honor, one thing that I did in preparation for today is I made sure, because I thought that would become an issue, the Rule 33 issue, and the court is correct. Typically, there is a little more that goes into determining if someone has falsely verified answers to interrogatories, and Mr. Kemp, I believe it was Mr. Kemp, actually asked those requisite, actually Mr. Rulis from Mr. Kemp's office, Nate Rulis, asked those requisite questions of Mr. Kemper during his deposition. I did
Do
not.
I have that in the
You
pleadings
do
before?
not. We have the deposition, but we did not reference it, I believe, Your Honor. What I would ask, because those questions were asked in his deposition, and he went over, in fact, the deposition questions with him during his deposition, and he did confirm that those are his responses to the interrogatories.
I am hearing what you're saying, Councilman.
But you
can
don't see it in
appreciate
front of
it. If I don't see it in front of me, they did not have an opportunity to respond.
That
Or
is
can't do a
true.
finding on something without giving all parties an opportunity to respond who choose to respond,
Sure.
particularly when you're talking about sanctions. So that's why the court was where the court was, in light of the nuance.
Your Honor, you are thinking ahead because I actually have Rule 33 circled to ask about it, so I understand the court's position. The other point, Your Honor, going forward, understanding the court did make a decision under Rule 16.1, and certainly witnesses and documents would be a part of that statement. Monetary sanctions, Your Honor, we believe are in order based upon the CCSD Richardson case. In that case, the time spent in having to present this to the court was resulted in a monetary fine against the defendants. We don't have the amount, of course, but we would ask that the ability to present a request in line with Brunzell so the court can consider those factors and award an appropriate sanction. The other thing we believe would be appropriate, Your Honor, and let me say that I ran these thoughts by Real Waters Counsel because I don't want to unnecessarily interfere or affect their position. And so these are things that we've agreed to, not necessarily the wording of the statement to the jury yet. We're going to work on that cooperatively. We'll forward it to ETT's counsel. But we also agree that the videos should now come in, Your Honor. We believe that Randolph was properly already identified, and Your Honor, you made a point of that. So he would normally come in. The only question would be his deposition if he was not available, whether or not that should come in. And I believe it should, since he was identified within the time period. But what we also believe is appropriate under Rule 16, and Your Honor, I'm taking this straight from Rule 16, because the court's correct. If the court's position is, since we did not mention 37 and do the things under Rule 37A, that you can't get the benefit of Rule 37 sanctions, under Rule 16, you can still strike witnesses without reference to Rule 37. And so the court's familiar with that. And under Rule 16, we're going to ask that ET&T not be allowed to call any witnesses in Phase 1, which is the compensatory part of this case. Because any witness they call would be to call a witness without us having the ability to cross-examine any of those witnesses because they failed to produce any of the documents they should have produced during the discovery period. Remember, the only documents they had promotionally was after the discovery period. They didn't identify these witnesses, what they would testify to for 3 years virtually. And that's allowed under Rule 16E3B. It says, in order prohibiting use of any witness, document, or tangible thing that should have been disclosed, produced, exhibited, or exchanged under Rule 16.1A. And so that's what we're asking, so that they are unable to call any witness during Phase 1. We believe Phase 2 is a different subject, Your Honor, and doing Phase 2.
And counsel, I believe I understand when you're talking about Phase 1 and Phase 2, you're talking about the current status of the trial. You're not talking about a pending OST that the court just received on a motion to bifurcate, which the court has not yet had an opportunity to address with any of you all because you appreciate. I really didn't even get it properly. I actually don't have it. Nobody.
You don't have it properly. You're right, Your Honor.
I'm just saying, but I'm not going to. You all know it. That's why I'm calling it a document.
That's right. And Your Honor, we discussed that yesterday. It was not properly served. It was not properly filed, I guess. And when I talk about Phase 1, and Your Honor, I appreciate you clarifying the record because I've learned in 30 years of practice, 30 plus years of practice, that every word in this transcript will be examined sometime later. And you're right.
It may be, so I'm just wanting to make sure everybody's on clarity.
So phase one and phase two for this discussion, Your Honor, is compensatory versus punitive.
Okay, go ahead, please.
And so, Your Honor, in terms of phase two, certainly there's a different standard under phase two, clear and convincing as opposed to reasonable doubt, and I'm sorry, beyond preponderance of evidence. So there may be different considerations for phase two. And we would suggest, Your Honor, that that in terms of witnesses, given where we are, and I don't know what this court's inclination is. I've had several punitive damage cases. Some you go immediately right into punitives. Some the court has allowed the jury to wait a day. I've had somebody wait a week. I don't know what the court's inclination is.
Stay tuned. We'll see what the facts dictate in this particular case, which is fair and equal to everyone if that situation occurs.
All right. And so, Your Honor, they may be different in terms of witnesses because we would need, they may call in witnesses in terms of deterrent effects or punishment. We don't know, and we don't know who they would call at this point. So it's hard for us to make a decision on phase two. And certainly in phase one, they should not be allowed to call any witnesses because we have not been given the opportunity to get the witnesses, documents that would allow us to even question their witnesses effectively because of their violations of the rules.
Okay, Real Water, I said I would ask you if you had thoughts. And the reason Terrible Herbst, I'm letting you go last because you probably want to hear what everybody else's thoughts are first. So let me hear theirs first, okay?
Thank you very much, Your Honor. Joul Odou on behalf of Real Water. Just very briefly, as to the potential striking of Terrible Herbst witnesses, we don't really have a position there. We don't think that's going to prejudice us one way or the other, whether that's granted or denied. As far as the negative inference or some sort of statement, that's probably the most objectionable one. We have serious concerns that could come back and affect the jury's award of damages against Real Water. And, obviously the devil is in the details as to what kind of statement or inference or whatever else the plaintiffs are requesting. And we have very serious concerns that could hurt Real Water. Not that it's here or there, but that was an issue that came up in the other trial. We believe that Real Water got hurt by that, and we don't want to see that happen again here. It was a completely different issue, but there was a limiting instruction that we tried to work out to mitigate the harm. We don't believe it was effective last time, so we, burned once makes us very leery of such a thing. The videos. We don't have a concern about the videos coming in per se. Don't really like the videos. I guess, again, the devil's in the details. It's what arguments are presented with those videos. If those arguments are used or those videos are used to ridicule Real Water, then there is prejudice. If those arguments are just, here are the videos that were shown as advertisements, then it doesn't prejudice Real Water. So I would say that if the court's inclined to allow those videos in, there would be no waiver by Real Water of any objection that they may have as to arguments as to the videos. Randolph.
Let me just pause for one second. When you
Sure.
said no waiver as to any argument of the videos, to their inclusion or the scope of their inclusion, can you just clarify where you would not want to have your...
So what we would suggest is the court's going to draw the line and allow the videos to come in, they're in. And then there would be no waiver, though, as to argument of argumentative or misleading, or if there's some other use of the videos by the plaintiffs that affects Real Water, we would still have the ability to object, and perhaps the court at that point would make a ruling. In other words, let's say they introduce the video of the woman jogging and there's an argument how ridiculous this looks. Again, that's argumentative. We would want to be able to make that objection. I'm not sure. The other video I think is a BMX person. I looked at it very briefly. Again, there's some argument that, I could think of a lot of prejudicial arguments. I don't want to give plaintiffs any ideas.
Yeah, no, where I was really trying to get a clarification is, I'd understood basically if it was in for notice for Terrible Herbst, Real Water was not necessarily having a concern.
Correct.
If it expanded past the notice for Terrible Herbst, Real Water wanted to reserve its rights. Is that
Yes, Your Honor.
Is that a fair kind
That
of...
is a fair characterization. The Randolph testimony, we have no position there. He was disclosed. If he comes in, that's fine. And as far as the sanctions, we have no position.
Okay. Terrible Herbst, go ahead, please.
Thank you, Your Honor. With respect to plaintiff's request for a statement to the jury, I agree with Counsel for Real Water. I think that would be extremely and unduly prejudicial, not just to Real Water, but to Terrible Herbst, and could be tantamount to a terminating sanction in and of itself, depending on what it says. And for the same, monetary sanctions, we would object, obviously, for the reasons set forth in our motion, and reserve our right to contest any of the sanctions that plaintiffs may claim, to the extent that the court is going to award those sanctions. With respect to the videos, I understand those are coming in. Is the court, I guess it's a request. We would object to their pre-admission, but understand the court's inclination to allow those in. So we would just object to the pre-admission. As for Anthony Randolph, no problem. As for the final request that that Terrible Herbst not be able to call any witnesses during the compensatory phase is tantamount to a terminating sanction, Your Honor. We would object to that. We don't think there's any basis for that. It's an end around of a motion to strike the answer. We would simply be sitting there with no defense whatsoever, and that is effectively a terminating sanction, and we would object to that.
Okay. Since you're already at the stage, let me walk through who Terrible Herbst, please, is anticipating calling, and if it's direct. Because remember last week I asked you all about who are the witnesses and who are the witnesses via depot, right? And you were somewhere around 12 to 15 with some overlap with some of the other parties. So by now, you all, I guess purportedly, right, met and conferred yesterday on depot exchanges and disputes yesterday. It's a break day, but at least I was told you were going to be doing. You are pretty darn close to doing your 2.67 if you haven't already done it, given your time frames and given the deadlines and dates that are necessitated. So, and the last day to disclose is already passed. So, you want to, I'm not going to ask you to give away your trial strategy or secret, but realistically, witnesses are witnesses, right? So, who is Terrible Herbst inclined at this juncture to come in and live or depot so I can evaluate the request by plaintiff and your counter request?
Sure. Our request would be to bring in Chris Kemper, the 30B6 witness for Terrible Herbst. Given that Mr. Randolph is likely going to come in, then we would want to call Mark Walters to respond. Depending on how it works out, Brian Breeden, he doesn't have much knowledge, but if there's going to be some, for example, statement to the jury, and I know they played some of his testimony, we would need to call him to explain that. Brad Sexton, and he's the IT guy for Terrible Herbst. Mr. Breeden didn't conduct the searches, Mr. Sexton did, so to the extent that we are going to have to establish the searches that were done for emails, communications, and we would ask Mr. Sexton to come in.
And refresh the court's recollection. Sexton's deposition was or was not taken, because I remember only seeing 3. I don't remember seeing his name specifically, but
His was not taken.
okay, not taken. Okay, go ahead, please.
He just started not long ago, so he's strictly IT. He doesn't have information on Real Water to communicate with it. And that would, for recipient witnesses, Your Honor, from Terrible Herbst, that's who we would just
Right. I'm trying to think who would be subject to the request by plaintiff. And like I said, the court just was evaluating a whole bunch of different ones. I'm going to give you all a heads up as to some potential, not saying that the court was or was not on each and every one of them, or all of them, or some subsection. I just want to hear. Okay. So, Kemper, Walters, Breeden, and Sexton. Is that correct? Okay. Did you have an opportunity to finish? That was the court's only question.
There may be another one. They have, plaintiffs have sent a notice of a deposition in the Wren case for one of our employees, again, who is in the IT marketing department, a newer employee. So depending on how that goes, and that's Kayla Adams. We anticipate the questions, although that's noticed in the Wren case, that those are really going to be directed towards, because we're not in the Wren case. We're not a, Terrible Herbst is not a defendant in the Wren case.
Then how could it have been deposed in the Wren case?
We've
The
asked,
court's not taking a position, it's not my case. I want to make sure everyone's talking about the right point. I can appreciate there's a lot of various plaintiffs going around, so it is in the Wren case, I take no position. Okay,
yes, that's, we're in the process of meeting conferring on that.
yeah, go ahead, no position. I just wanted to make sure I heard it
Yes.
correctly. Okay.
Your Honor, can I respond just briefly, knowing that I have to
Let me
leave in
make
a few-
sure that Counsel
Oh, I
Terrible
thought
Herbst
she
is
was done. I
finished first,
apologize.
but yes,
apologize
I'm
before
going to give you an opportunity to briefly respond since it was your motion. Go ahead. Counsel Terrible Herbst, did you have an opportunity to finish or not?
I think we finished with the no witnesses. I think I hit on all 5 of their requests, Your Honor.
I appreciate it. Thank you so very much. Okay. Counsel for Plaintiff, you wanted a brief response?
I do, Your Honor. I appreciate
Somebody
it.
else arguing the MSJ because we're going forward with
Yeah,
that
I'm gonna
next.
have to let someone else argue the MSJ, Your Honor. I don't think there's much left to argue on that one, but, Your Honor, the first thing is, Ms. Rojas mentioned Kayla Adams. She's never been listed in this case. So now they're trying to expand the list as in violation. She's never been listed in any of their disclosures.
I believe she said if plaintiff was planning on calling her because you're taking her deposition,
In a different case.
are you intending to potentially call her in this case?
I don't think we should have to call anyone, but let me tell you what, let me just address it, Your Honor. We did not intend, because we haven't listed her. She came up after the discovery deadline, and that's when and you can tell, I raised it
In
in
your
my motion.
earlier argument when you were.
Yeah,
anyway,
exactly.
yeah.
She's never been listed.
Okay.
And so this to me goes to what ET&T has tried to do, or Terribles has tried to do throughout this case. Chris Kemper wasn't identified until September 25th, 2023, almost 2 years later, after their initial ECC. And he had same circumstances and facts as how he's described. None of the documents, none of the emails, nothing. We had no real ability to depose him effectively without any of that information. Mark Walters was done September 25th, and so was Brad Saxton. It wasn't.
She said, I think you mean Mr. Breeden.
Mr. Breeden and Mr. Saxton.
Mr. Saxon was not deposed because Counsel for Terrible Herbst said Mr.
He was
Saxon.
not. He
Okay.
was not.
Go, please.
He was not. Your Honor, this is why, and unless you read the cases carefully more than once, in Bohina and CCSD, the court says striking witnesses is not tantamount to a terminating sanctions, because under Rule 16, what you're trying to do when you're the offending party, you want these witnesses in because you know that you've not done what you're supposed to do under discovery to allow the opposing party to truly vet them as a witness for trial, or how they affect your discovery efforts. So what she's trying to do, Your Honor, is get her witnesses on, despite failing to comply with 16.1, both on the production side and the witness side, and asking that we be confronted with this trial by ambush, because we still don't have the documents. We still don't have the promotional materials. We still don't have the marketing. We have none of those things that they should have produced to allow us to effectively actually depose and then cross-examine them at trial. Your Honor, it's not tantamount to striking their answer because they still get to question our witnesses. That's the difference. Where if you were to strike their answer, they don't get to cross-examine our witnesses.
Let me ask a question.
Sure.
With regards to you still do not have the marketing materials and promotional materials.
You don't?
What my question is going to focus on your reasonable belief that additional marketing and promotional materials exist and are no longer, will either A, destroyed, B, not produced, C, some third option. The court's not limiting it, right? I'm just trying to get an understanding of your reasoning on why things exist versus what you already do know about the stills and the videos.
Because Mr. Breeden said no one even asked him to pull from his department those records. And that's what his deposition was that I showed you page.
Right, that was the emails.
That's,
Right. But Mr. Breeden, do you know if Mr. Breeden, was the 30B6 asked that with regards to the topics which would have included such promotional materials? Was he asked the question?
Mr. Kemper was asked, let me see if I have it in front of me, Your Honor. Mr. Kemper was asked about,
Where I'm going is, was Mr. Breeden the right witness to ask?
Breeden was not the 30B6, Kemper.
Right, that's what I'm saying.
Yeah.
Was Breeden the right witness to ask that question of?
He, in our opinion, he was, because he was the head of that department, marketing and promotion. That's why he was the right person to ask.
Versus the IT person versus
Versus the
30B6?
IT person. I mean,
Versus
this
the
guy
30B6.
said it would have come through his department. He said Kayla Adams worked under him. This is why this guy, in our opinion, he knew about the pump and pour. He says those records are still available. That's why I showed you page 43. He said, in terms of commercials after 2018, it would have come through his department. And again, he wasn't identified until late. Let me see if I can tell you when he was identified exactly. Yeah, November 2nd, 2023, the day after the close of discovery. That's when he was finally identified. And that's his department. So, Your Honor, what they're trying to do is circumvent the rule after violating Rule 16.1 to disadvantage us in terms of our ability to effectively and thoroughly cross-examine these witnesses. And yet they think they should have the right to bring them here. That's incorrect. That's not what Rule 16.1 says on its face. It says just the opposite. If you violate Rule 16.1, the court can strike those witnesses. So for every witness you found they violated the rule, those witnesses, by virtue of the rule, should be precluded. And so we're not asking you to do anything beyond what the rule requires. And they did violate the rule in terms of all of those witnesses. And they certainly have violated the rule in terms of documents. When you don't have your head of that department search his records, I mean, he told us on November 2nd that he was not asked to search his records, his own records. So, Your Honor, we believe that we can work something out with Real Water that we can present to the court that would not negatively affect their position. And we also believe that we can tailor it so that it only punishes the party who violated the rule. And so we ask that the court consider and take it under advisement and at least let us present something to you so the court can take everything into context at one time.
Okay, I appreciate it. Here's the court's ruling. Court's going to do as follows. The court already gave us analysis why it felt sanctions under applicable law, etc. was appropriate. I'm not going to repeat that. Now the question is, what are the lesser sanctions that would be appropriate in this case? Okay, let's go to the easiest one first. The easiest one first is monetary sanctions. Some portion of monetary sanctions is going to be allowed. Here's the court's thoughts on that. It's not going to get to include the supplemental brief that plaintiffs wanted to do with regards to Randolph, because that was you all's choice, the date you chose to take that deposition, particularly since he was disclosed back in May. But I'm going to evaluate the other information. Also, it's not going to include the time period specifically for today's hearing. The reason why not is there were other issues that were coming before you were coming before this court anyway. I don't see that as additional time. However, I do think that there is, with regards to the conduct, the necessity of writing the initial brief, the initial reply brief, and then I'll hear if there's some other aspect that the court hasn't specifically included or excluded, and let people address it. The way court handles monetary sanctions is this court generally lets the parties determine first if they can come to some type of agreement, because oftentimes spending the cost to do the whole Brunzell analysis and argue everything, you may have some kind of agreement on what an amount is as a liquidated sum, and then you all can create it and treat it how you wish to treat it, versus sometimes party comes to agreement that it may not be viewed as sanctions. It may become an agreement between the parties. The court's not taking an affirmative position on that. I'm just telling you this court's custom and practice to allow the parties to first kind of see if you can work an agreement on that. But if not, then I'll evaluate monetary sanctions. I'm giving you some guidance on certain inclusions, certain exclusions. I'm not going over every single thing. If you think it should be included, it's not specifically excluded, you're going to have an opportunity to do so. And counsel for Terrible Herbst have an opportunity to say it should be excluded, okay?
Sounds great.
And of course, that's court, we need a Brunzell analysis. With regards to the videos, they're coming in. I am not waiving Real Water's rights, so right now I'm seeing those videos coming in for notice only with regards to Terrible Herbst. I'm not, if they're going to be utilized or there's going to be any questions on any other aspects, then that's going to need to come to the court before they are played, before said question is asked, outside the presence of the jury, and everyone's got an opportunity. And realistically, the first question I'll ask you if that happens is, have you coordinated with the other parties so that they've had an opportunity to know what you're doing, so people have an opportunity to be fully prepared, okay? And that's with regards to the two videos, and can I just call them the jogging and the BMX videos, or is there some other way you'd like to refer to them as?
Fine, Your Honor.
Jogging and BMX videos, everybody knows what we're talking about?
We do, Your Honor.
Yes,
Thank you
Your
so
Honor.
much.
Counselor Terrible Herbst?
Yes, Your Honor.
Okay. Those are the only ones I know about with this juncture. Okay. Randolph deposition. There's going to be two prongs on the Randolph deposition. If Randolph is allowed to come in, if he's coming in live, then the court can address objections at the time of his testimony within the scope of how he would come in as a lay witness, normally just like anybody else, since he was, like I said, disclosed as it mentioned back, I think it was number 44 in the May 2023 disclosure by Terrible Herbst. So, and then that would be subject to individualized objections at the time of trial with regards to any questions, okay? That needs, and I think that takes care of any issues that Real Water might have, because you still have the right to do your individual objections. Should take care of any issues with regards to Terrible Herbst, because you take care of individual objections, okay? And that would be confined to the scope of his deposition. So if there's some new area that pops up between now and when his deposition, right, in the time of trial that wasn't his deposition, once again, you need to let the court know so everyone has put on notice, everyone has an opportunity to be heard, because my ruling is impacted by what is currently known by this court, which is the deposition, which everyone had an opportunity to be present at, okay? So if there's a new area, I mentioned that. If he is intended, he cannot be reached and he needs to come in via deposition designations, I'm going to have to do a carve-out, because I don't like to make assumptions, but would it be correct that you all did not do depot designations for Randolph yesterday?
We did.
Oh, you did? Oh,
Yes,
one
ma'am.
step ahead. Thank you so very much. Then guess what? Okay, so then I will, then they're teed up for the 27th, is right? With the other depot designations? Okay.
They will be, Your Honor. We're going to meet and confer and have them teed up.
Okay, so then you don't have to have a new date on that. I was going to see if I had to have a different date for Randolph. You hadn't had a chance, so, but you have, so great. So that would be on the 27th with the other ones. So that part, if you're doing it via deposition, so that should take care of those issues and actually will clarify the live issue as well, because rulings obviously would apply if he's live on certain topics. So that takes care of Randolph. So the court is issuing that, and those are appropriate sanctions. Now let's get to the pure exclusion of witnesses. No. The court really, I have to look at the nature of what the issue is, and I have to look at the nature of what the motion is, and I have to look at the individual obligations that are required, and I have to have a sanction that meets all of those. And when I look at sanction meet all of those, the preclusion of all of Terrible Herbst's witnesses, I do not find is an appropriate sanction. I find it's too harsh. Where the court was going with some type of instruction is, I think, that what you could articulate, subject to how the parties are going to request this of the court, is that there could be something in the instruction that makes it clear that these witnesses were designated on X date. And so I think that implicitly takes into account their late disclosure, and so with whatever aspect would come in. Now, once again, it's going to matter if they're coming in live versus deposition, right? Because of the amount of cross-examination. If they're coming in via deposition, I might have to revisit this. If they're coming in live, where the court is addressing the issue. And what the court, however, is not allowing by its prior statement, saying that other witnesses can come in. When the court's making its statement realistically, Kemp, Walters, and Breeden's plaintiffs had a full opportunity to depose. All parties in this case had a full opportunity to depose. So realistically, the court doesn't see the prejudice. Well, disclosures were insufficient. Disclosures were untimely, but having a full opportunity to depose those parties, I think, mitigates the potential prejudice to plaintiffs. There's still prejudice because realistically, you have the compounded issue of certain information still going to said instruction. But that's why I'm really going to have to see what the requested relief is, because this court is not going to. You all are experienced litigators. You know you don't want to create an issue, right, by asking for something that might come back in a different context to the parties. So the court is going to find, if there's something presented to the court that there needs to be addressed to the jury, something couldn't have been inquired with regards to one of those witnesses because of not having the documents, etc., or the fact that there needs to be, well, I'm not going to go to any more specifics. I have to see what you all are proposing. So I'm leaving open, I'm deferring the instruction, okay?
That's
I'm
what I
not
was
saying I'm
asking.
specifically granting it, not granting it. I'm going to defer to see what is proposed to this court in light of where you all are at, in order to, and hear a little bit more argument after I see what's being proposed as to how that would be necessary in addition to what the court has already stated with regards to appropriate sanctions.
Perfect,
Okay,
yeah.
I think that gives everyone the full opportunity to address that. I think it addresses all the various concerns, and people can revisit what you really need. That's where the, so just one run off video. So I've taken care of all the requested prongs. The court's already analyzed the non-striking aspect of the answer in general and the witnesses. And like I said, the court is, that's not an invitation to bring in witnesses that were not timely disclosed. Those I'd have to address on a case-by-case basis, my rulings with regards to those 3 witnesses that had an opportunity to be deposed. Okay?
Thank you.
Thank you so very much. It is so ordered. That's the court's ruling. I understand one of the council needs to leave, so council, feel free to do what you need to do, and we're moving on with other councils.